I will be advising the Birmingham Ballet Company on their potential liability arising as a result of the detailed scenario. Tony's claim against the BBC is in the tort of negligence. Firstly, actionable damage would need to be established. Tony has suffered physical damage as a result of the BBC. As per the de minimis non curat lex rule, stated in Rothwell, damage must be more than minimal. Lord Hope explains that damages are given for injuries that cause harm, not for injuries that are harmless. Tony would satisfy this rule as he has suffered a life-changing injury of blindness. Tony would also be able to claim the actionable damage of pure economic loss as he will experience a loss of earnings due to his inability to continue performing in the show. Now we need to determine whether the BBC had a duty of care towards Tony. Generally, the exclusionary rule applies to prevent a duty being owed in respect of omissions, as stated by Lord Goffin Smith. Courts are reluctant to implement duty when there is no positive act. This is due to the potential monetary impact in which a potential compensation culture could arise. In Stovin v. Wise, Lord Nichols states that there is something more required than being a bystander. However, there is an exception to this general rule when there is assumption of responsibility or liability. In this case, the assumption of responsibility arises out of the pre-tort relationship of employer-employee, as per Wilson v. English. The stagehands can be considered as an extension of the BBC as they are hired by them to keep the stage clear. Watson acknowledged that there is employer's responsibility for the safety of employees, which denotes a positive duty to act, giving rise to omissions liability. It is likely, therefore, that a duty of care will be established, as the BBC were aware that the stage would be used for rehearsals, yet they failed to ensure that the conditions for the dancers were safe. We must then establish that this duty has been breached by the BBC. To test whether there has been a breach of duty, the reasonable test would be used. In the case of Paris, Lord Norman detailed that any reasonable prudent man would follow usual practice. The stagehands failed to clean the stage, which would have been reasonable and usual practice in the scope of their employment, as they were hired to keep the stage clean for shows. Therefore, a breach of duty will be demonstrated. Finally, causation will need to be proved, in which Tony will need to show that the breach of duty from the BBC caused the actionable damage of his blindness. Factual causation must first be satisfied using the but-for test as established in Barnett. The eye injury would not have occurred but for the presence of stones on the stage. The BBC could potentially argue that the eye drops administered were a supervening act. However, this would not be satisfied because the injury and medical procedures were not two separate events. It is evident that but for the original eye injury, the consequent eye drops and the surgery would not have been necessary. We must also consider whether this breach of duty was a legal cause of the damage. We must question whether the kind of damage was a reasonably foreseeable outcome. The original eye injury was reasonably foreseeable and not too remote. In some cases, the actions of third parties can break the chain of causation. In this case, it's possible that the medical intervention would break the chain of causation. However, it is unlikely that the courts would consider this a novus actus intervenens, and legal causation would therefore still apply. The eggshell principle will be appropriate in this case, meaning that the BBC are responsible for the whole harm. Furthermore, courts often refrain from putting liability on medical professionals due to policy considerations. Bolam details that the defendant is not guilty of negligence if he has acted in accordance with a practice accepted as a proper by a responsible body of medical men. Moreover, as in Webb, Dr. Riff's medical intervention would only break the chain of causation if it was completely inappropriate. A possible defence for the BBC would be contributory negligence, a statutory defence which can be found in the Law Reform, Contributory Negligence Act 1945, Section 1. This defence shifts some responsibility on the claimant for the damage. Unfortunately for the BBC, this argument would be unlikely to succeed because Tony did not act in an irrational way by responding to medical advice, and this is an element required for the statutory defence. It is likely that Tony's claim against the BBC will succeed. The claim for personal injury will be successful, and therefore he will be able to claim damages for his economic loss as he is unable to perform in the show. I will now discuss Maria's claim. Maria is bringing a claim in the tort of negligence. Maria's actionable damage is physical injury, in the form of mesothelioma. This was contracted from touching her husband's work clothes, which are covered in asbestos. The actionable damage is physical harm. Statute deals with physical harm in the Limitation Act 1980, Section 38(1). In this Act, unless the context otherwise requires, personal injuries include any disease and any impairment of a person's physical and mental condition. Mesothelioma is a cancer that affects the skin and therefore will constitute as a physical damage and therefore an actionable damage. A duty of care will then need to be established. There is not a pre-tort relationship between Maria and the BBC, as she is not an employee of the BBC. Consequently, the courts would look to precedent case law to assess whether there is a duty of care here. Maguire would be the most appropriate analogous case law, in which the claimant's secondary exposure to asbestos from her husband's clothes resulted in her contracting mesothelioma. However, as this was a pre-1965 case, the circumstances are far removed from the scenario to be completely analogous. The courts would therefore look to the Caparo test to assess the duty of care. The first question that needs to be considered in determining if it was reasonably foreseeable that the defendant's failure to take care could cause the damage to the claimant. In 1965, an article was released in the Sunday Times which exposed the fatality of asbestos, meaning the danger of this was public knowledge. Therefore, it would be reasonably foreseeable that the second-hand exposure to asbestos would be dangerous to the claimant. A relationship of proximity would then need to be established between the claimant and the defendant. Due to the close proximity between the husband and wife, we can assume that there would be a relationship of proximity, as it is likely that she would come into contact with the danger. Finally, we must assess whether it is fair, just and reasonable that the law should recognise a duty on the defendant. A policy consideration to the courts would be whether this would open the floodgates to claims. However, due to the extent of the danger, the courts would likely decide that the BBC would have a duty of care towards Maria. We then need to establish that there has been a breach of duty. The BBC will be judged on the breach of their duty using reasonableness. In the case of Currie, it was concluded that all employers are subject to a duty to take reasonable care to prevent exposure of its employees and members of their families. This then follows on to state that this is the case regardless of any potential exposure attributable to other employers. It is not clear what precautions were taken by the BBC to protect Bernardo from exposure to asbestos and in turn protect Maria from exposure. However, it was evident that the BBC failed to successfully eradicate this risk. Therefore, a breach of duty will likely to be established. Furthermore, factual causation will need to be demonstrated in this case, in which, but for the action of the BBC, Maria would not have contracted mesothelioma. In Bonington, it was held that the risk of the dust coming into contact with someone's skin was material enough to establish causation. The likelihood of her having developed this disease as a result of the BBC's actions and her exposure to asbestos would be greater than 51%, and therefore factual causation would be achieved. In this particular case, we would use the Fairchild principle, as more than one employer has materially increased the risk of Maria's exposure to asbestos and the risk of developing mesothelioma. Fairchild is a strong policy decision in favour of compensating those who have suffered great harm by employers. Consequently, Section 3 of the Compensation Act states that all employers will be liable for the whole sum of damages, and Maria would receive compensation as a result. Finally, legal causation must be established. It may be possible for you to argue that it is not reasonably foreseeable that Maria would be affected directly by the asbestos, as she was not an employee. However, according to Currie, even though Maria did not enter the place of work but contracted it from the clothes, it is still reasonably foreseeable and not too remote. There will be no defences applicable in this claim. It is likely that you, the BBC, will be liable for both Maria and Tony's claims in negligence.